Hi, it's Angela here with Legal Document Preparers, and today we're going to do a general overview educational video about the dissolution process here in Sacramento County, specifically default dissolution. A true default is what they're called, where only one party files the paperwork and the other party is non-cooperative or they don't appear, and the petitioner is the one who does everything. What we're going to use as our guide is the court's 10-step roadmap. I know you all know about this roadmap. A lot of people call me about it. You can be found on the court's website. It's completely free. It's also on my website under the resources tab, along with a lot of other free resources that might be able to help you through your dissolution. And so there's 4 general steps in the 10-step roadmap. And the great thing about this roadmap too is it can be used for not only dissolutions or divorces, it can be used for legal separations, it can be used for nullities and annulments. So that's great. Anywho, so let's get started. So basically, step 1 is where you open the case and you put things at issue. For example, if in your case you have minor children, then you want to address children, child support, and child custody. One really important thing to remember on a true default, if you don't address it in your petition, you're not going to get it in your final order. So a lot of clients come to me, they're frustrated because they have to start all over again. Yeah, they have to go back, amend their petition, revise it, to address the issues that are applicable to their case, and then they've got to serve the other party again. And that 6-month clock starts all over again too. Yeah, so, be thorough in step 1 to make sure you're addressing everything, especially if you want orders for property division. Make sure you have those here addressed in step 1. Okay, the next thing, once you open your case with the court, after the initial filing is done, then you go to step 2. That's serving the other party. So there's different ways to serve the other party. This step 2 packet you can, of course, personally serve is always the best. But in cases where couples are cooperative, you can also serve the other party by mail. Well, not you personally, somebody else over the age of 18 needs to serve them. Here at Legal Document Preparers, that's one of the services that we include with all of our document preparation packets, is basically we serve the other party by mail. And with this initial pleadings, we serve with it's called a notice of acknowledgement and receipt. And so the other party acknowledges and signs on this date they receive the documents. And so that's a great tool for cooperative parties. And that way you don't have to hire an expensive process server or track down a friend and ask them, hey, can you serve this on my ex for me? And it can get quite awkward. And so, yeah, but that's a great tool that the court has for you guys, the notice of acknowledgement receipt. And again, it's always included in all of our document preparation services here. Step 3 is the financial disclosures. These documents are actually exchanged between the parties, so you can serve these documents on the other party. And basically, your income and expense declaration, you schedule assets and debt, or property declaration, whichever you choose or is applicable in your situation. But basically, that's the financial disclosures. It's to let the other party know, hey, this is what we have, and if you don't know or didn't know, now you know. A big deal about the financial disclosures and about this whole case in general. FYI, your court case is a public record. Anyone can access it. So if you file any sensitive documents, make sure you redact your social security numbers, date of birth, driver's license numbers, any account numbers, anything sensitive that should be protected. Because guess what? Employers go down there, government agencies go down there, private companies go down there, stalkers go down there. So we want to keep your information private. And if you file it in the court file just regularly, it'll be accessible by anyone. So be careful about that. Technically, only the FL 141 needs to be filed, especially if you're not seeking any financial orders, and it says it right here. And that document is just the proof of service that you exchanged the financial disclosures with the other party. Okay, so big tip, watch out for that one. And then step 4, your judgment. And we're hitting the coming to the end of the road. And so step 4, you have quite a few options, but we're particularly speaking about a default, a true default where the other party doesn't respond. And so you can do one with without a hearing, and with a court hearing. So if you want to go in front of a judge, go for it. Follow this packet, you file your FL 165, and then at the window they set you the default hearing, and then you go in front of the judge. If you don't, then you get this packet together and you do your judgment, your default request, make sure your disclosures are filed, and then you do the FL 170, that's also in this packet, and then you get that submitted. Oh, and the FL 192, the notice of entry of judgment. And then you get submitted this to the courthouse, and then one of our lovely Sacramento County commissioners will review it, either approve it, and if they don't approve it, then you'll get, it's called a rejection letter. But, and don't feel bad, the rejection letter is a purple document that you'll get, and it'll give you notes. Hey, you missed this, you did this, da-da-da. The commissioners are really great about giving you feedback of what needs to be done. And if you're stuck or you're frustrated and you've given up and you're like, I don't want to do that, then bring it over here. We can use that rejection letter as our guide of how to make the necessary corrections. Part of our service here is we, prepare the documents. We make the necessary copies. I'll file it with the courthouse. You don't have to worry about any of that stuff. And so if you're looking for a help and you just want to hand off the task of assembling everything and putting it all together, give us a call. We'll definitely help you. But even working with us at Legal Document Preparers, you are representing yourself, because we're not attorneys and we don't represent clients in court or advise them of the law or their rights. And this business isn't a law firm, and we don't sell documents for them either. What we do is we prepare documents of client-specific direction. And that's why this roadmap, these packets are so great. The rejection letter is great, actually, because then you know what to do. You're being advised by the judge themselves how to make the corrections, okay? Or what corrections need to be made, okay? And they have a checklist. They finish this, incomplete, da-da-da-da-da. And so it's very, very helpful. I hope this has been helpful for you. I wish you the best of luck. And if you want more help, give us a call. We do 30-minute consultations for $50, and we can help go through that judgment checklist with you. If you decide that, you know what, you take it from here, then that $50 can be credited towards document preparation services. So I hope this helps. Best of luck to you.